Assalamualaikum. We are from Group 4 and we'll be presenting the topic of bail. I am Nur Ain binti Mohd Azman.
I am Nur Adlina binti Syahrir.
Hi, I'm Nurul Izza binti Muhammad Rafi.
And I'm Iman Solehah binti Sallehudin.
Hello Ain.
Hi Adlina.
I just want to remind you that today we're gonna have criminal procedure class, right? We're going to learn bail, right?
Oh yes,
Have you studied about this topic?
I have just finished studying this topic.
Oh, that's great! Since you have studied this topic, can you briefly explain to me the definition of bail?
Literally, bail means setting aside or releasing a person from custody or arrest in return for that person or other persons agreeing to guarantee his later attendance at the court. This guarantee is given by the persons in question signing a bond which binds them to ensure the attendance of the accused at court and to pay a sum of money in the event of his non-appearance. In Yusuf bin Muhammad against PP case, Abdul Malik Ishaq J stated that bail in simple language means security taken from a person to appear on a fixed date before the court. The meaning of the word bail as ordinarily and commonly understood to set free a person who is under arrest, detention, is under some kind of restraint by taking security for his appearance. The rules and procedures governing release of the accused depends upon whether the offence of which a person is suspected to, bailable, non-bailable or unbailable. The terms that are used in the Criminal Procedure Code, namely bailable offence and non-bailable offence. However, there is another term of bail known as unbailable offences. This term is not mentioned in Criminal Procedure Code, but it is understood to mean offences in which an accused will not be given bail in any circumstances.
Oh great, now I'm more clear and understand what this bail actually means. Thank you so much, Ain.
Most welcome, Adlina. I have also read the types of offences, but I don't really understand regarding to the bailable offence. Can you explain it to me?
Sure. So basically, bailable offence is in bail. There are several types of offences. The first type of offences is known as bailable offence. By virtue of Section 387 of the Criminal Procedure Code, any person detained for committing bailable offence has a legal right to be released on bail. However, it is subjected to the bailable offence as stated in column 5 of the first schedule of the CPC. The police that may grant the bail must be an officer in charge of the police station or any police officer not under the rank of corporal. Further, the police may release the bail by police bail or personal bond without sureties. That is good behavior. In theory, whether the accused has any priors or is likely to flee, he should be granted bail as a matter of right. In the case of a bailable offence, no condition can be imposed on the accused's release. In the case of Wong Ki-moon versus Public Prosecutor, the word shall be released on bail given their literal and natural meaning that bail must be offered to the accused as it is mandatory under Section 387 of the CPC. In Muhammad Jalil bin Abdullah versus Public Prosecutor case, it was held by the High Court that, although records for the applicant were bad, he is still entitled to bail as a matter of right as the offence in question was bailable offence. Now I need to differentiate between bailable and non-bailable offence. Unbailable offence? I think I should ask Izza. Yes, I should.
Adlina? Hello, Art. What's wrong?
Hello, Izza. Izza, help me, Izza.
Are you okay, Art?
No, I'm not, Izza, please help me. I need your help, Izza. I really need your help. Because I want to clarify about the concept of bailable offence. No, I mean non-bailable offence. Yeah, that's it. Because it's slightly confusing me, so I really need your explanation. I hope you can help me. That's my problem. Yeah.
Astaghfirullahaladzim, Adlina. You're scaring me. I thought something bad happened to you. Thank God you're okay. No worries, Adlina. Let me briefly explain to you, okay? Regarding to non-bailable offence, non-bailable offences can be seen in Section 388 of Criminal Procedure Code, where the court has discretion whether or not to grant bail for non-bailable offences depending on the circumstances and fact of each case. Under this section, there are three types of offences, where the first one is offences punishable with life imprisonment or death penalty, where there are no reasonable ground to believe that he is guilty of the offence, but there are sufficient ground for further inquiry, where the trial court may grant for bail. This can be seen in the case Datuk Mat Shah versus Public Prosecutor, where the court will lean in favour of granting bail unless there are strong grounds that bail should be refused. High Court has unfettered discretion to grant bail when the offence is punishable with death or life imprisonment. Therefore, there are few factors that need be considered before the court can use its discretion for granting a bail where it's cited from Malal Criminal Procedure. Firstly is whether there was or was not reasonable ground for believing the accused guilty of the offence. Secondly, the nature and gravity of the offence charged, whether serious or not serious. Thirdly, the severity and degree of punishment that might follow. Not only the nature, but look at the severity as well. Then, the danger of the accused absconding. The court will look into the history of the accused, his character. There are also character, means and standing, demeanour, appearance and also history. There are also danger of the offence being continued or repeated. There are also danger of witnesses being tampered with. Next, opportunity to the accused to prepare of the defence. Last but not least, long period of detention of the accused and probability for further period of delay. Then, the second types of these offences under Section 388, where secondly, offences punishable with life imprisonment or death penalty, where there appears reasonable ground to believe that he is guilty of the offence. It shall not be released means no discretion. However, it does not mean that the offence is unbailable. The thirdly or the lastly is offences punishable with life imprisonment or death penalty, where there appears reasonable ground to believe that he is guilty of the offence, but it falls under proviso, where the offender is whether below the age of 16 or a woman or a sick or infirm person. This is exception where the bail can be given. According to the third exception, there is a case where Public Prosecutor versus Lechumi Pawan Ahmad. The judge, the respondent was a woman charged with the offence of murder under Section 302 of Penal Code. The respondent granted bail in Magistrate Court, and against this order of the bail, the Public Prosecutor appealed. In allowing the appeal and the High Court cancelling the bail, where the present case that the only grounds on which this application for bail was granted by Magistrate Court appeared to be that the accused is a mother of 10 children and the youngest was still breastfeeding. The reason put forward in this application fall of being exceptional and very special reason, therefore application should have been refused. However, there is case where the bail can be granted. In the case of Che Su binti Daud Guncet Tuan, judge, accused together with husband and brother, charged with the offence of drug trafficking under Section 39 of Dangerous Drug Act, where punishable with alternative of death or life imprisonment. The accused has 6 children and the youngest while breastfeeding. The court held that it allowed bail because it distinguished with the case Public Prosecutor versus Lechumi. In this case, it is less serious offence where the baby breastfeeding. There is also unbailable offence that I don't really understand. Better I call Iman for better understanding. Iman. Huh.
Hi Izza, what's up?
Hey Iman, I'm having trouble understanding unbillable offense. Could you explain it to me? Pretty please.
Why, of course, I am happy to help you. So basically, unbailable offense is... Now what is unbailable offense? Unbailable offense is said by Mr. Sallehudin, who is a lawyer and an academic, said unbailable offenses do not fall under the penal code, and those are which the court simply have no discretion to grant any bail, regardless of the punishment of the offenses carried, or the gender, the age, or the health condition of the accused. Now this is different to non-bailable, because non-bailable leaves room for the accused to be granted a bail, while unbailable, it simply does not care in what condition or situation you are, it will never grant you bail. Now, what are some examples of unbailable offenses? Well, firstly, you got the drug trafficking, which falls under Section 39B of the Dangerous Drug Act in 1952. There's also kidnapping cases under the Kidnapping Act in 1961, which carries the death penalty. There's also Section 3 of the Firearms Increased Penalties Act 1971. And lastly, offences which carry the death penalty or life imprisonment under Section 57 to 62 of the Internal Security Act 1960, or certified by the Attorney General to be security case under the Regulation 2 of the Essential Security Cases Regulations 1975. Now, bail is not allowed as mentioned before, and the accused person shall be placed into custody until the end of trial. However, there is a slight teeny tiny problem with unbailable offenses. It is often misjudged as non-bailable offenses. This happens because there is no provisions regarding unbailable offenses anywhere, not even the Penal Code or the Criminal Procedure Code. For example, in the case of Samirah Muzaffer, who is charged under Section 302 of the Penal Code, and this offense is actually punishable with death or lifetime imprisonment. Now, she was accused of murdering her own husband and Cradle Fund CEO, who is known as Nazrin Hassan.
Alright, the court demands silence. I shall be announcing the decision that we made. So the federal court came to a unanimity to grant bail on Samirah Muzaffer. With that, case dismissed.
Oh my god! Yes! I was granted bail. In this case, the federal court decided that this offense is considered as non-bailable offense instead of unbailable offense, which had truly rocked the legal world, and everybody was shocked. That's why there should be an amendment to the law regarding the unbailable offense, making sure that it is included somewhere in the Penal Code or the Criminal Procedure Code, where people can follow it and make it as a precedent. And in case any confusion happens, no more of that.
So what we can conclude, the concept of bail is that it acts as security lodged by the accused person on the basis of which he can be released on a temporary basis but needs to appear in a court whenever required by the court. The process of bail takes place while the trial of the accused person is pending. Generally, a person seeks this option in order to get himself released from police custody. These provisions envisaged in the code gives the brief regarding the provision of the bill, and the process of bill is a legitimate process. That's all from us.
Bye.
Thank you.
Assalamualaikum.